on to join us. Just a brief introduction for those of you who haven't done a webinar with Dan or myself. Dan and I are both attorneys at A-Tully Rinckey PLLC, and as Taylor mentioned, we're both partners and we work in our security clearance practice group here at the firm, as well as our military law practice group. So Dan and I are both veterans. Dan's a veteran of the Navy, I'm a veteran of the Army, and we've both been in the intelligence community or cleared space for both of us more than a couple of decades in some capacity. Dan and I are both members of the Security Clearance Lawyers, the National Security Lawyers Association. If you get a chance to check that out, you can find us online, NSLA, or National Security Lawyers Association. It's a nonprofit that we have actually founded, that we set up to help provide training like this and assistance to everybody in the intelligence community, from security officers through individuals who are requesting security clearances. And as part of that, we have put together a series of webinars. Today we'll be talking about Guideline A, which is allegiance to the United States, kind of a niche area. This isn't a guideline that gets talked about all that often. You've probably heard of the most common ones: Guideline F, financial considerations, criminal conduct, drug use, things like that. Those are the more common types of guidelines. But occasionally we'll run into a Guideline A case, and we'll talk about some of those cases today and how we've litigated some of those cases, and hopefully provide some information to anybody that watches this webinar that might help you avoid liability or keep you from triggering a Guideline A adjudication. So why is this relevant now? There's a lot going on in the across the world, especially in the United States. There's a lot going on that that has brought Guideline A to the forefront where it normally wouldn't be. One of them is what we call J6, the January 6th protests, riots, demonstrations, whatever you want to call them. Probably depends on your political affiliations, because that tends to be how people draw their opinions about what happened on January 6th. And Dan, I'm sure, is going to get into this in a lot more detail, but naturally, there's a bunch of security clearance cases now involving what occurred on January 6th. Some of them are appropriate, for some people who maybe used force or advocated for violence against the government during that period of time. Some of them probably inappropriate, involving people who, might have just been tangentially involved in what they expected to be a demonstration. So Dan will talk more about that in detail, but we've also got the upcoming election. So, something to consider when you're looking at potential liability. What are you going to do over the next year that might jeopardize your security clearance? And then also, as we're all aware, there are some pretty heated legal battles going on with President Trump now. So you should be careful, and we'll talk a little more detail about why Guideline A might come into play if you're going to attend some of those demonstrations or rallies. So at this point, I am going to turn it over to Dan. But first, just a quick disclaimer. Anything that we talk about here today is just our opinion as attorneys. We're not in any way affiliated with the government, and this isn't, legal advice to anybody. We're just talking in general terms and kind of walking through Guideline A.
Great. Thank you, Tony. So, as Tony said, this is a sort of outline guideline, even though it's the first in a document called SEAD-4, SEAD-4. It's the Director of National Intelligence guidance to all the heads of the departments inside the executive branch, the offices. There are about 72 of those offices, and each of them has a security office, and they all run personnel security programs to vet and clear workforce for eligibility for access to classified information. So if you're in the executive branch, you have a security office, which moves up through your agency head, but your agency head is organized under the Director of National Intelligence, not in her capacity as spy chief of the nation, but rather in her capacity as the president's go-to person on personnel security. In that regulation, SEAD-4 has Guideline A, and it's the first guideline, allegiance to the United States. And you would think, well, that might be the top priority if it's the first guideline, but these cases are so hard to adjudicate that there's very little track history on them. Tony's done a couple of cases. I think more of my Guideline A cases have not gone to adjudication than gone to adjudication. We'll talk about that a little bit later. And that's for a very good reason. The Alien and Sedition Acts, back in the beginning of the Republic, okay, back in the Federalist era, kind of met a sour end, okay? The Supreme Court in general really requires a high burden of proof for treason, high burden of proof for sedition, and there's a zone of protected speech around a lot of activities of American citizens. And if you're a public employee and an American citizen, you have First Amendment protection, a little qualified, for your activities. So they can't go after you for speech issues within a sort of bounds of appropriate behavior. And that's what you have to be careful of, is not to step beyond the protective bounds that the courts laid out for you. Why is this happening now? Well, the key thing for everybody to remember is the narrative may change. Right now, we have Capitol Hill divided between two parties. And we have a minority in the House that's kind of running the House. And their view on what might be treasonous or seditious is probably going to be different than over in the Senate. You have a Senate aligned with the White House. And then you have a Supreme Court that I think is very hard to predict. So it's very hard to figure out what the message is when you look at the big picture in the United States. So for federal employees, that means you got to do the turtle tactic. You need to get inside your shell, hunker down, because the storyline could change in 4 years, right? We have a presidential election coming up. January 6th may be viewed as an entirely different event after that election. And that may be a good thing or bad thing to you based on your political leanings. But it's going to be a reality. And it's going to be a reality that federal employees have faced for a very long time. There's nothing new in any of this. This has been going back to the very beginning. I'll just give you a couple of tips based on things that happened prior to the security clearance program being inked in its final form in the 1980s and 1990 and updated most recently 2012 and 2017. Very important when you look at historical examples to remember that the law has changed. And what you really want to focus on is speech is protected, actions not so much. But there's some important clarifications on that, particularly when it comes to the Second Amendment. You got to be very careful. Early Republic, you know the names, General Benedict Arnold. You may not know the name of General James Wilkinson. Both of them senior Army officers and both involved in actions that various people thought were treasonous against the United States and showed poor allegiance to the United States. Wilkinson was only cleared because he dropped dropped the dime on Aaron Burr later, and so people thought somewhat better of him. Vice President Aaron Burr, okay, he got out at trial, right? So he wasn't convicted, but a lot of people thought he was trying to set up a separate country based out of New Orleans. And he fled to Europe after the trial and then came back and was a rather successful attorney. Good harbor for former traitors. You can go and become an attorney in the United States when you come back. Civil War, very hard in our culture to characterize that time period. Some people regard the succeeding states as filled with people who were traitors. Some do not. That in and of itself tells you that there's a storyline that is still open in our popular culture, and we haven't figured that out. Some of those officials lost their citizenship for a very long time. I remember the ceremony in I think it was about 76, when Jimmy Carter did something with regard to Robert E. Lee's status. The Lee family actually showed up at Arlington. Something was restored of his status to the United States. Let's roll up to World War II. Whole series of propaganda prosecutions. Those you got to be careful about watching because that's speech, okay? And providing comfort to a foreign enemy, enemy of the state through your speech. There's going to be a lot of protection for that now. Jane Fonda during the Vietnam War, a lot of people wanted to see her prosecuted as a traitor, but you know what she did was for the most part, speech. The visit to Hanoi was, I think, an action, but in the end, there was no prosecution in that case. During the Cold War, a whole bunch of allegiance to the United States cases, some involving the nuclear secrets, the Sobel case, the Rosenberg case. Also in the Cold War, we would include 1985, the year of the spies. This is something to be very careful to watch for, because they were basically run-of-the-mill federal employees, and the KGB got inside their heads and basically got them to turn against the United States. Aldrich James, Robert Hansen, John Walker Jr., Ana Montez. That was the Cubans got Ana Montez to flip on us, and she was just let out of prison, I think, last year. You need to focus on the year of the spy in 1985 if you're a federal employee, because that's really the beginning of training for federal security officers. In every course they go over, what were the lessons learned in that year that so many of our secrets were turned over to the Russians and the Cubans. After the Cold War, there's a period I call the clash of cultures, based on the work of a Harvard professor by the name of Samuel Huntington. These are the ones that from our own lives. I would say the Fort Hood incident, Major Hassa down there would be in that category. There are others. There were certainly lots of prosecutions around 9/11. And that gets important to events we're seeing today. Certainly the conflict in Gaza is sparking various activities in the United States, and any federal employees that are aligned with organizations that are engaging in extreme activities could find themselves reviewed for those. So that's a general sort of background of many of the types of situations that people found themselves in. Some may have thought when they were taking their actions that they were on a path to someone questioning their allegiance to the United States. Some may not have. Some in their heads, they may have cooked up a narrative that thought what they were doing was perfectly acceptable. One thing you might want to think about if you're looking for some fiction to read, there's a book I keep an eye on, because when they do new movies on this book, I'm always interested to see if we're like in another sensitive time period in our nation's history. Edward Everett Hale was the first PhD in the United States back in the 19th century. He gave the speech before Lincoln's address at Gettysburg, the one that nobody reads anymore because it was impossibly long. I think he spoke for like 7 hours. But he wrote a short book during the Civil War called The Man Without a Country. And it's a story of a fictional Army lieutenant, Philip Nolan, who's prosecuted for treason, and his punishment from the court is to never hear another word about his country. So he ends up on naval ships for the rest of his life. He's imprisoned on naval ships, and not until he dies during the Civil War is he given any news of what had happened in the United States since 1807. That book speaks a lot about how Americans think about treason, and it's been remade in the film form. Think about these years: 1917, 1918, 1929, 1937, 1943, 1947, 1953, 1957, 1973, 1977, and 2016. I think that Hollywood runs for that book as a storyline when they see that we're in those tough situations. So that's a little bit of the history behind what allegiance to the United States frames for security officers to think about. Now we'll switch over. Tony, I think you have some thoughts on the structure of the regulation itself, Guideline A.
Yes, sir. Thanks, Dan. So we'll talk just a little bit black and white. I'm actually going to go through Seed 4, which Dan just mentioned. That is the Security Executive Agent Directive 4, and that is a directive that applies to all to all individuals under the executive branch and the adjudications that take place. And I'll read specifically from the document here, so there's no question about the purpose or who this applies to, but I'm reading directly from Seed 4. Under purpose, the purpose is to establish a single common adjudicative criteria for all covered individuals who require initial or continued eligibility for access to classified information or eligibility to hold a sensitive position. And if you're wondering if Seed 4 applies to you, you can jump to the paragraph right under there that talks about applicability. This directive applies to any executive branch agency authorized or designated to conduct adjudications of covered individuals to determine eligibility for initial or continued access to classified national security information or eligibility to hold a sensitive position. So if you hold a security clearance, if you work for an agency where your job requires a security clearance, then Seed 4 applies to you. You should familiarize yourself with it. It's a 27-page document, but in that document, you'll see that it actually lays out each of the 13 adjudicative guidelines. And as Dan has mentioned, Guideline A is obviously the first of those 13 adjudicative guidelines. And they deal with everything from allegiance to the United States, to drug use, to psychological conditions, alcohol use, criminal conduct, a whole myriad of different issues that could come up in the adjudication of your security clearance. So familiarize yourself with that if you haven't already. We're going to jump to Guideline A, and we'll just talk briefly about the concern and some of the issues that could cause a triggering of Guideline A, and then some potential ways that you might be able to mitigate those concerns. And we'll just talk in general terms, and then we'll actually get into a discussion about some of the cases that Dan and I have previously worked that at least involved Guideline A. So the main concern is just a willingness to safeguard classified or sensitive information. And, anytime that this concern comes up, anytime there's a potential doubt about an individual's allegiance to the United States, and that's explained in a paragraph at the start of Guideline A in the adjudicative guidelines here. Now, there's no clear black or white indicator that shows if an individual is allegiant. It has good allegiance or strong allegiance to the United States. There's no way to know for sure what countries an individual is allied with or what country they support the most. But what they look for are indicators, and what an adjudicator or an investigator is going to look for are negative indicators. So if there's a reason to believe that an applicant or a clearance holder has shown negative indicators, in other words, has shown that there's a question about their allegiance to the United States, then they'll either get a tentative denial, or potentially a revocation of their security clearance. And you can jump down to the next section in Guideline A, conditions that would raise a security concern and maybe disqualifying include, and you'll see there that there's a list of different types of conditions that those investigators are going to look for, and that a judge or an adjudicator might look for, and you'll have to make sure that your indicators show positive and that you have the least amount of potential negative indicators as possible if you hope to overcome the triggering of a Guideline A. And some of these are involvement in, support of, training to commit or advocacy of any act of sabotage, espionage, treason, terrorism, or sedition against the United States. That all sounds pretty extreme, right? But it's not, your interpretation doesn't necessarily matter as much as the investigator or the adjudicator's interpretation. A lot of times people are involved with groups or they support groups and they don't realize that they're supporting a group that quite obviously to other people would fit into this category. And there's a bunch of them that we'll talk about, but Antifa is a common one. 3%ers is a common one for military members and veterans, which shocks a lot of people when I say that. We'll talk about that in a little more detail as we wrap up our webinar here today. But just going back to involvement in or support of, that doesn't mean that you have to physically be there to support an organization. If you're making donations, if you're online, commenting on a forum, you're liking social media posts, you're sharing things, if you're doing things like that, you are supporting that organization. And if that organization falls into this category, it could be an issue. And, we're talking everything from, like I said, J6 all the way to Ukraine. The different things that are going on in Ukraine. Have you supported an organization that was supporting the Ukraine and the ongoing war in the Ukraine? And was that organization an organization that might fall into this category or one of the other categories that the government looks for? So if you jump down to in that same section, if you jump down to C, another one that comes up and that's pretty easy to get tied to is association or sympathy with persons or organizations that advocate, threaten, or use force or violence or any other illegal or unconstitutional means in an effort to, and this first subsection there is overthrow or influence the United States government or any state or local government. And that's where the January 6th issue comes into play. So if you advocated for a group of people or you were involved with a group of people who were attempting to overthrow the government, which is, frankly, a little far-fetched in this, if you look at the real facts of January 6th, but it's not going to be difficult for an adjudicator to draw the conclusion that there were groups of people there that were at least attempting to change the outcome of the election or influence the outcome of the election. And that in and of itself is enough to fall squarely within Guideline A. So take a look. I'm not going to go through and read every single condition, but there's 3 different conditions, and the third condition has 4 subsections under that condition that you should take a look at if you think that this might apply to you, or if you're thinking about taking part in any rallies or upcoming political demonstrations. I strongly urge that you review these guidelines before doing so. But just like any attorney would tell you, if you do those things, here's how we might be able to assist you in working through them and potentially keeping your security clearance. And that's outlined in the next section, which involves mitigation. So some of the types of mitigations are that you would show that you were unaware of the unlawful aims or purposes of the individual that you supported or the organization that you supported. So for example, initially you thought January 6th was just going to be a peaceful demonstration, which you have the constitutional right to take part in, and it went south and you didn't take part in the illegal activity, you didn't actually storm a government building or anything like that, then there's a good chance that you can mitigate those concerns by showing that the group that you initially allied yourself with or supported wasn't expressing that they were going to be involved in anything unlawful. Another one is that the involvement was humanitarian or permitted under U.S. law, and this is where the Ukraine might come into play, some type of support there. You were attempting to give humanitarian aid that you understood to be permitted under U.S. law, and there's questions about military service and all these other things that we're not going to get into there because they can actually trigger other guidelines as well. And then the next one occurred for only a short period of time and was attributable to curiosity or academic interest. This one is fairly common. We will see, or we'll at least deal with clearance holders or applicants who can argue and have argued that their involvement in a certain group was for educational purposes only, and that it was short-lived, and maybe they were in college or they're doing some kind of study and they moved away from it. That is a common form of mitigation as well. And then finally, activities occurred under such unusual circumstances or so much time has elapsed that it's unlikely to recur and does not cast doubt on the individual's current reliability, trustworthiness, or allegiance. And that is an argument that I've made in multiple cases, because people who tend to get themselves in trouble in social media, things of that nature, it's usually reactionary. Sometimes alcohol's involved, sometimes unique circumstances. They will make comments that come back to haunt them later because the internet is forever. People tend to forget that. And sometimes you can make the argument, or we have successfully made the argument, that that was unique circumstances. It's unlikely to recur. For example, President Trump winning the election in 2016 caused some people to put some pretty questionable comments out on social media that they had to answer for later. And I was personally involved in adjudicating one or more of those cases. So that is the regulation. Again, I urge you to check that regulation. Familiarize yourself with it, especially if you're going to be involved in any political activity coming up, or you're involved in any of the groups that we might have mentioned or considered getting involved in those groups. But for now, we're going to jump ahead and we're going to talk a little bit about some of the previous cases that have come up that Dan and I have had the pleasure of working.
Okay, so before we get into the actual cases, a little bit of recap on the past history, at least since the security clearance program was put into place. So we look at the 20th century, a little bit of prequel prior to the 1950s. Some things to remember. We had a presidential candidate in, I think it was 1922, Eugene Debs, who was in jail at the time of the election, prosecuted for sedition. Woodrow Wilson had him locked up, had his opponent locked up. Debs was running on the Socialist Party and ended up getting, I think, just over 900,000 votes, which is a pretty strong showing for a third-party candidate in the United States. So this is not new. We've had people run afoul of the federal government for their political views. In the case of Debs, everybody looks back on that situation and wonders whether that was really the appropriate thing for Woodrow Wilson to do, but Wilson won. Or actually, I think the Republicans won that one. Wilson was going out at that point. During the Civil War, remember that there were prosecutions of Copperheads in the North. These were Northern sympathizers with the South. This is important legally because one of the most important cases for limiting military courts-martials, Ex parte Milligan, was in fact about the prosecution of somebody. The court eventually said it should have been a civil trial, not a court-martial. And it was for that person's views, Mr. Milligan, on supporting the South during the Civil War. And then a lot of people don't understand that the Army even did a court-martial of a congressman, Clement Van Landingham, who was a Copperhead, and Lincoln ended up overturning the court-martial himself, not wanting to incite problems in Ohio, where the congressman was from. During the Cold War, I talked about a few of the spy cases. There was some famous mishandling of security clearance cases and sedition and treason cases during the Cold War. If you haven't seen the movie Robert Oppenheimer's, the Oppenheimer movie, that movie is the beginning of the security clearance program that many of you are under. And so if you want to know why we have all this due process, it's because that handling of his security clearance adjudication was really a travesty. They malign the poor guy. I personally think it's because he was Jewish. I don't think it was because he was a Marxist in his college years. I think they went after him for his religious beliefs. But in the end, that got cleared up. But you should watch that film Oppenheimer to understand the context of the system you're in. There's been a little bit of discussion of Whittaker Chambers in the last 10 years about what he was guilty of and what he was not guilty of. But a lot of people think that Whittaker Chambers was innocent of the espionage charges levied against him. And everybody forgets about the Lattimore case. Owen Lattimore was accused during the McCarthy hearings of being responsible, I think it was for the loss of China in 1949. And that was a case in which somebody's reputation was absolutely hammered as these loyalty and security programs developed. There was a big initiative in the 1950s funded by the Rockefeller Foundation under the leadership of a professor at Cornell University called Robert E. Cushman. Professor Cushman got a grant, and they did lots of studies on the security clearance program as it was being administered. Walter Gellhorn was one of his writers, a young academic who went on to do a lot of work that influenced how lawyers were trained, actually, even up until the time I was in law school in the 1990s. Even more important, there was a young undergraduate in Professor Cushman's class as he was doing these studies, learning civil liberties from him by the name of Ruth Bader Ginsburg. And so particularly for the women on the call today, the beginnings of what I would call the Supreme Court's addressing of women's rights issues in the 1960s and 70s came out of the review of the security clearance program, because one of the students that benefited from that research was a future Associate Justice of the Supreme Court. Moving into the civil rights movement and focusing on federal employment and people being vetted for employment or people having clearances, you have to, everybody forgets now because they're all focused on J6 and former President Republican Party. But years ago, it was the other side that was under scrutiny in the civil rights movement and the peace movement during the Vietnam War. Lots of federal employees were placed under investigation for their political views and their views on the civil rights movement. One of the more interesting one was a fellow by the Harvard professor by the name of Morton H. Halperin, who had been a deputy secretary of defense and on the National Security Council. I think he was National Security Council in the Johnson administration, and then he was deputy secretary of defense, I think, in the Nixon administration. Played a very pivotal role working with Henry Kissinger on the production of the Pentagon Papers that were eventually leaked. Became a famous case, the New York Times case. Halperin came back in the Clinton administration in 1993 and was challenged. And he was challenged for his political views. Professor Halperin was a little center, left of center in his politics. Some would say more than left of center. And Gerald Solomon, representative from New York State, challenged him in the appointment and said that he would not get a security clearance if he was a routine federal employee based on his views. Morton Halperin's son, by the way, Mark Halperin, you may have seen as a commentator on MSNBC. If you see that name, that's a father-son connection. The reason why I raise that is even recently, I know of federal employees being put up for positions that required Senate confirmation. So you spend your whole career as a Fed, you get to the point where you're pretty senior, maybe you're a GS-15. Somebody says, hey, we got a position you might want to have, and it's, probably low down on the political appointments. Former federal employees typically aren't Secretary of State. I know of several that were challenged by Republicans who did research on them and found that they were members of the Students for a Democratic Society in the 1960s. So they were protesting at Stanford or protesting at UCal Berkeley or at Columbia. It's in the record, it's somewhere out there on the internet. They get put forward for a position. Everybody starts looking into their past, and all of a sudden the red flags go up. That level of scrutiny could return to the general federal workforce if Guideline A gets any air beneath it. So as we start talking about the cases that Tony and I are going to highlight, how to describe the current environment, I think, is very interesting. I've called it Clash of Cultures, based on Samuel Huntington's book on that topic. But Huntington was talking about global politics in the Middle East and the West and all that sort of big 40,000 level foot information. I think Clash of Cultures, actually, you need to extend that thinking. I think part of it also, if you think about the last 15 to 20 years in particular, we're seeing a challenge on the concept of federalism post-Cold War. So during the Cold War, we were all united behind the bomb, right? We were worried about duck and cover and, somebody nuking our towns and the day after and nuclear radiation, all that stuff. And that tended to keep Americans pretty focused on a strong federal government. Once the Soviet Union fell and everything became very complicated and asymmetrical, as we used to say in the Defense Department, our focus is not on the federal government like it used to be. And that comes about in two critical areas. The first, you've seen plenty of examples of: technology, surveillance, monitoring. So all of those things that sparked Ed Snowden's moment back in 2013, or Reality Winner, who was an NSA employee down in Georgia, or Tom Drake and his friends at the National Security Agency. All of those people were concerned about the federal government's size and its potential for collecting information on the American people. That is really, if you think about it, a anti-federalist position. They're worried about the civil liberties of people, about the government being too big and too strong. And I'm a Democrat, I'll be honest with everybody. I say it up front, even to my clients who I know are Republicans, so they can ask the firm to get a Republican if they want one. And I'm a little center or left of center, but I'm a big fan of civil liberties. And on the whole January 6th matter, I'm not as dismissive as many of my federal Democrats are of those people who were on the Capitol during January 6th, because part of what I'm hearing from them, and some of them are my clients, are similar concerns that I heard from all the technology whistleblowers who had their moment back in a decade ago or so on matters of electronic monitoring of the population. So all of that weighs in on security and how they vet people, because security has to figure out how to have a safe and trusted workforce without opening the workforce to people with allegiances to others than the United States. And the big turn with January 6th is, instead of the others than the United States being a foreign country, it's internal, the focus. There's lots of discussions about the Russian role on January 6th, but the bottom line is those were Americans up on Capitol Hill. So if there's division, it's division within the United States, not between the United States and another power. So with that in mind, that little prequel, Tony and I can talk about a couple of cases. Tony, you want to talk about yours first?
Sure. I don't intend to get into details too deep here, but I'll just briefly discuss a couple of the cases that I recently dealt with. And some of you may know this, some of these cases are published, not all of them, depending on where the individual works and in what capacity they have a security clearance or where it was adjudicated. But not all of these cases are published. Even the ones that are redacted. So, Dan and I will not be talking about clients by name or providing any identifiable information. So, but just in general, I've had a couple of recent cases. One of them was an individual who was accused of aligning himself with Antifa. And some people might be shocked by the fact that aligning yourself or supporting Antifa can land you in this situation. Maybe not anymore, but earlier, maybe a few years ago, Antifa probably didn't have the same, connotation that they have now, or the same expectations that they probably have now in the national security community. In other words, people who were demonstrating with Antifa or involved in Antifa-related activities probably didn't expect to find themselves accused of violating Guideline A or any other guidelines. But as some demonstrations got a little out of hand or got a little, maybe criminal, and there were obviously acts of violence, things of that happened that moved them into a position where many people see them as maybe a terrorist organization or an extremist organization. And obviously, a security clearance adjudicator can make that determination because, again, as I mentioned earlier, it comes down to that reviewer's interpretation of your actions or the organization that you've aligned yourself with. So this individual, for example, he was on chat groups online. Most of what he did, I believe maybe all of what he did, was online. So from what I recall, I don't believe he was actually physically present at any Antifa events. But he was online, he was in chat groups where individuals had identified themselves as Antifa members, and he was communicating with them, he was taking part in conversations, and was copied in on planning of certain events, things of that nature. And when he sat down and completed his SF-86, he was asked questions and provided some information in response to those questions on the SF-86 that caused the investigator to kind of go down that rabbit hole with him during the initial investigation or interview. And during that point in time, the investigator, who happened to be a Marine Corps combat veteran, took issue with the fact that this individual had been participating in a forum for Antifa members and, in my opinion anyway, exaggerated some of the responses and some of our clients' involvement in those forums, and made it so bad that our client was initially denied a security clearance, and we did a written response, which I thought was a very thorough written response, and I expected to win that case. I don't always expect to win the cases on a written response. I seldom do, and I expected that we would win that case on the written response because we had provided pretty much everything that was in question. All the comments, we've provided all of the different web content that we were able to get our hands on, and we still had to go to a hearing. And department counsel in this hearing actually took a very unusual step in putting the investigator on as a witness. It's the only time I've ever dealt with that, and I think it's a big part of why we won the case, because this investigator was so overzealous that he had basically given my client his combat experience and his background and in an attempt to shake my client up and tell him, you know, I'm a Marine, I'm a combat veteran, and I'm offended, and he kind of laid into our client. And I used that information against him while he was on the stand, because there's no reason any of us should have had that information. And the only way we could have had that information is if he used it when he was beating my client up during the interview. So that kind of turned the tide a little bit in the hearing, and we were able to show, which I previously mentioned, that my client was involved in some of these things for what we believe were academic purposes. He was really just kind of learning about Antifa. That's why he hadn't been to any events yet. It was short-lived. It was under unique circumstances. You know, all the different mitigation that I already discussed. We were able to lay all of that out, and thankfully, we were able to get our client a security clearance, and he was able to go on with the job. And you know, he was a really good candidate for the security clearance. Similarly, we had another individual around the same time. Another case where an individual had made comments in an online forum. President Trump had won the election, so I'm going back quite a bit here now, but President Trump had won the election, and I'm sure everybody that's on this webinar, if you paid any attention at all, you remember that night. There were a lot of people shocked that night. There were a lot of people who expected Hillary Clinton to win that election, and it didn't happen. And a lot of people were offended, felt personally attacked, and a lot of people lashed out. But again, these are very unique circumstances. So some people went on social media, some people went into these chat rooms, these forums, and they made comments. And people assume, just because the government doesn't say that they're monitoring your social media, your emails, all the different stuff you're doing on the internet, they say they're not monitoring it, but of course they are, at least to a certain extent. And an individual made a comment, something along the lines of, where's a suicide bomber when you need one? Things like that. Made a few comments. There was alcohol involved. It was immediately after the election results were issued, and he was remorseful in the morning and immediately went and deleted all those comments. But it was too late, because the internet's forever. So same scenario played out. It came up during the application stage, came up during the adjudication stage. We took it to a hearing and argued, unique circumstances, again, alcohol involved, a lot of different things going on. In this case, we actually put on evidence that the individual had sought treatment to deal with the stress and anxiety that individual felt following the release of those election results, and that the proof that individual had sought treatment was actually what got us over. So it's a good thing that we did that, and that individual was able to obtain a security clearance as well. So a lot of different things play out, but those are some non-January 6 cases that we've litigated here recently, and how we were able to overcome those cases. But I'll turn it over now to Dan. I'm sure he's got some January 6 stories to tell.
So yes, Tony. And then before I do that, I frequently get summaries from our associates of the research we do and the various rates of revocation within particularly the Defense Department. And I focus a lot on private corporations and contractor clearances. And I think it would be helpful for the group to kind of put this in perspective, sort of Guideline A findings against contractors when compared to the other 12 guidelines. And as we've mentioned in these webinars in the past, the biggest levels of revocation and denial still remain under personal conduct and financial consideration. Okay, so that's nowhere near Guideline A. Personal conduct in many cases is lying on your form, and financial considerations is managing your finances and paying your taxes. Right below those two, there's a group of, I would say, 3 guidelines. That would be G, alcohol, H, drugs, and J, criminal conduct. And those are all about substance abuse for the most part. On criminal conduct, even the domestic violence portions of those, I found with my clients that there's some alcohol consumption or drug consumption prior to the act that leads to the police call that ends up with a Guideline J trigger. So you can already see that the focus of the security office is on, first and foremost, personal conduct and financial considerations, then substance abuse right below it. Then there's a small trickle of cases relating to sexual behavior and handling protected information. I'm always surprised that we don't find many Guideline K proceedings handling protected information, given how critical that function is on the security side. When it comes down, and then the two that are always kind of the surprise, Guideline A, no revocations or denials over in the Defense Department in my latest survey. And outside activities, Guideline L, none. I almost had a Guideline A L case in 2019, but the client elected to leave federal service instead of preserving the security clearance. So this boils down to the one category I didn't mention, foreign influence, which there's a healthy amount, probably about the same amount as drug involvement and alcohol involvement. And foreign influence can play, along with its twin right next to it, foreign preference, into the Guideline A concerns. I think what happens in these adjudications is it's so difficult to get their heads around the Guideline A allegiance issue that security will start going after you for something else. Okay, it'll look for foreign contacts, it'll look for foreign ties that lead to preference, or it'll try to find something completely unrelated to their initial concern. So what they're kind of doing is a surrogate action, sub rosa, trying to take you out to something else. Before I talk about the J6 experience most recently, one of the cases I go back to and highlight for the Doha judges when I appear over at Ballston is one of Braden Murphy's cases, which was handed down in 2019. And I think it's important enough. I'll read a little bit from the abstract that I often give to judges to remind the judges of their own decisions. It's a good thing to do. In that particular case, the statement of reasons alleged that until at least January 2015, the applicant was a member and high-ranking officer of an organization that advocates sedition against the U.S. government, advocates the use of force and the violence to overthrow the U.S. government, and to prevent others from exercising their lawful constitutional rights. That last language, and to prevent others from exercising their lawful constitutional rights, that language, very similar to the prosecution language of former President Trump down in Georgia. So the applicant acknowledged that he had been a member of the organization, but denied the characterizations and aims of the group as alleged. So here we see this often in security cases. There may not be a dispute about the facts, but it's the way they get painted in the statement of reasons that, frankly, would not necessarily happen in an Article III court of law. So there's a little bit of tilt. Security investigation's not neutral. There's a little bit of tilt to the language. And that's the characterization that becomes the battle in the adjudication. So according to the government in that case, and the decision handed down by Judge Murphy, the group advocates racial and religious genocide, and its founding documents can generally be described as racist, anti-Semitic, and homophobic. In March of 2000, applicant was interviewed by an agent of the Defense Security Service and described himself as a skinhead since 1991. However, the applicant stated that he was not in any formal group or organization of skinheads and only practices the beliefs in private. Applicant also denied ever having a discussion about issues relating to sedition or overthrowing the United States government. Judge Murphy found that the government did not establish that the applicant had placed the welfare or interests of another country above those of the United States. No foreign country or entity is involved. Moreover, the government neither alleged nor established under Guideline A that the applicant's failure to adhere to the laws of the United States or violation of the law is harmful to the stated U.S. interests. Moreover, Judge Murphy found that the group's beliefs did not advocate sedition or overthrowing U.S. government. Based on this, the applicant mitigated concerns under Guideline A. So that's a pretty high bar for the government. That having been said, some of the events on January 6th have led to significant activities under Guideline A. Not in the Defense Department, which I found very interesting, but over at Homeland Security, And over at the Justice Department, particularly the FBI, there have been a large number of investigations underway since January 6th. FBI pulled all the flight manifests in and out of Washington, D.C. for a period of time before and after January 6th. They know everybody who was coming in and out of town on an airplane. They have used Google data, which is freely available. You go out, you're walking around, your phone is broadcasting your position, friends of Tully Rinckey. Everywhere you go, it's like having a little tracker on you. And if law enforcement wants to get that information after the fact, unless you've turned your phone off, and even that doesn't stop the transmission, you're going to end up as a red dot on a big map. And FBI has pulled everybody's location who had a cell phone running around Capitol Hill on January 6th, and they've tried to piece together what people were doing from that data. I'm quite sure that metadata has been pulled from all private telephone companies. So when you make a cell phone call, that's not a private call, folks, okay? Marketers buy that information all the time. They can't get your content, but they can get who you called, when you called them, what time you called. That's why you get those calls at very awkward times, because somebody's pulled the data and run a profile on your telephone usage. So once you have the to and from number, you can then start indexing it through a supercomputer and find out who's talking to whom. And if you have a person you know was committing a seditious act, you can then get everybody that person called, or that called to that person. And you can start then creating what's called link analysis or web analysis of what everybody was up to. So the key thing for federal employees to remember, and this is what J6 really has, sort of focused me on, is that, privacy's gone. It's gone. Okay. There are people who want to, go off grid and unplug, but even that's difficult given that there's cameras on lots of street corners now. So you have to walk in public as if you are on a street corner somewhere. So what were the takeaways from the J6 cases that I've handled? There were about 8 of them. Most of them did not go to adjudication because access was pulled. The client was suspended without pay. They then had to make a decision how to keep a roof over their head because they had no pay. Some went on to find jobs at non-government organizations and other places. But many were pushed out and into loss of jurisdiction. As you may know, if you've focused on security clearance matters, if you leave sponsorship of a clearance and then you have loss of jurisdiction, it's very difficult to get a clearance back. So that played to the government's hands. Focused on that, I want to just, before we wrap up here, focus on a DIA example that I found very illustrative. I'm going to scrub it a bit so we don't give out the client's identity. The client was very active on social media, which was rare for the intelligence community because it used to be dissuaded, but I have found that intelligence executives aren't as hawkish as they used to be on social media. But the media this particular client was focused on was internal. And it was following the George Floyd incident. We're pre-January 6th, but this is part of the federalism discussion. My client reposted the commander-in-chief's comments. That was President Trump. And all of a sudden, we were staring at a Guideline A proceeding. And my client did really well. And I'm not saying I threatened security, but I said, look, my number one defense is going to be the guy was reposting the commander-in-chief's comments. But what people need to realize is that wasn't generated by investigators out there scanning. That was internal to the agency. Somebody didn't like the comment and they went after our client for it. And that client's doing very well now. It's worked out quite well. So with that, Tony, I'm going to give a few things that I think are takeaways on how to lower profile, and then maybe you'll have some that are better than mine. Does that make sense?
Sounds good. Go for it. Thanks.
So I think it's really important to know SEAD 4, the regulation we've been talking about. Yes, your local regulation is important, but those are often written in very wonky language. SEAD 4, written by the DNI, is written very well. It's a easy read. And I make my clients promise me they'll read it not on their birthday every year. That is really wonky, but the week of their birthday, just so they're refreshed on it. Nothing's more tragic than talking to a 20-year, federal employee, who got all the way to their 20th year and didn't understand that they could just go on the internet and read the mystery of the security process right there in SEAD 4. So also, when you're talking about your membership in other groups, limit it to speech as much as possible. You want to speak, that's great. Be very careful about actions. Now, there's certain actions that the Supreme Court has deemed to be speech-like and they're protected. But as a federal employee with a security clearance or as an applicant who wants one, you don't want to be fighting the battle that your act was in fact speech. And then if you are a federal employee, remember, don't pick up the phone and call Congress. Don't contact the media unless you've read the regulations regarding media and congressional access and you've complied with them. Yes, that means you may have to register as going to Congress with your public affairs office or congressional liaison office. But lots of times employees will get stung on violating that regulation. It's an easy out for the agency. Oh, that's our regulation. You violated. We're going to fire you. And folks, Congress won't necessarily stick up for you if you were their source. They have very limited tools to protect federal sources. Very difficult in this world, but if you can, stay off record. Guideline A, like Guideline D, sexual conduct. It's better if it's not filmed. It's better if it's not taped. It's better if it's not on Facebook. I know a lot of people want to use social media to speech, and it's part of our way these days in America. But for your federal security clearance, if it's off record and security can't find it, they got to have a witness. And a lot of people don't want to, narc, frankly, on their fellow employees. And then resource yourself. Okay. Yeah, we're lawyers. We're in the business of protecting people's clearances. But and it's so hard with childcare costs and trying to save for retirement, meeting the bills, inflation, gas, food. It's just annoying right now. But you got to have a war chest. Every employee has to have a war chest so that you're able to defend your clearance if it's challenged. And that includes checking into the federal employment insurance options as well. You can't use insurance to go after somebody, but in some of these proceedings, you can use insurance to pay for counsel, but you need to check all that out well beforehand, and you have to have that insurance before you actually are in trouble. Tony, any thoughts from you?
Yeah, just a few as we wrap up here. So there's a slide up here that just kind of goes through the different positions you might find yourself in. You might be a service member, you might be law enforcement, you might be a civilian employee, and by that we mean an employee of the federal government, an agency employee. You could be a contractor or an employee of a contractor who employs with the federal government. You had to get a security clearance as a result. This applies to all of you. So just a couple things to keep in mind to protect yourself from liability. Make sure that you avoid supporting and to the extent that you can, any kind of contact with any group that could potentially be an extremist group or seen as an extremist group. If you are a veteran, and I say this, I've been in the military 27 years, I'm not, this isn't a knock on veterans or anything like that, but if you're a veteran and you put a 3%er sticker on the back of your pickup truck because you thought it looked cool and you think that you're being patriotic by doing that, you're actually doing the opposite. So you should understand what the 3%ers are. The 3%ers are essentially the 3% of the population, the early Americans who stood up and fought against a tyrannical British government. So if the United States government believes that you are holding yourself out to be the 3% of the population that's going to call them tyrannical and fight them, obviously they're going to consider your activities to be aligning with or supporting an extremist organization. So by putting that sticker on your truck, the argument can be made that you're advocating for violence against the government. So you should consider taking that sticker down, especially if you're driving on and off of a federal installation and you have a security clearance, which is required to do your job. but also Antifa, obviously Proud Boys, these other obviously extreme organizations, any type of organization that is based on some type of divisive, skin color, something like that. You want to distance yourself from those groups if you hold a security clearance and you think that there's a potential that any of them could take part in any extremist activities. Keep in mind the election is coming, so if you are military, this is kind of guideline A, but a little broader than that. Make sure that you're not going and doing speaking engagements in uniform. Make sure that you're not putting out your opinion to be the opinion of the service or the federal government. Make sure that you're not in a federal installation or sitting in your army office on social media and blasting the current president or things like that. Just distance yourself from the military, distance yourself from the agency you work for as this election comes up. I'm not saying don't demonstrate. We all have the right to support a candidate, and you should support the candidate that you think is the best candidate. You should be active. Just be careful in how you do it, and don't do anything that might jeopardize your security clearance in the process. That's all I've got, Dan. Oh, I'm sorry, one more thing. And this was a question that came through actually about donations. So it's really the main question that we wanted to talk about. I know we've only got a minute or so left here, but the question about donations. Is it an issue if you donate to a political figure? Probably not. But if you overdo it, and if you donate to organizations that might be seen as extremist organizations, if you're showing that you're sympathetic to those types of organizations, then you could cause an issue. You could cause a Guideline F issue if you over-donate and you spend too much money. It could become a financial considerations issue. So there's a bunch of things that could come into play. Just don't overdo it, and be careful with who you're sending your money to, because yes, your donations could potentially lead to you having your security clearance revoked. Dan, any closing thoughts?
No, Tony, I think that was brilliant.
All right, well, again, thank you all for joining us here today. We're gonna keep these going. We've been doing a webinar here every month or so, and we intend to keep doing that moving forward. Again, check us out at National Security Lawyers Association. You can find our website online. Tons of content there. Dan does, I think, an interview before and after lunch every day. It seems like it anyway. But there's tons of interviews. There's tons of articles that have been published. We are as active in the community as we can be, and we offer content quite often to different organizations. I have a lot of stuff that is published through the clearjobs.com. clearjobs.net. So check some of that content out. Again, National Security Lawyers Association, and you can check out our website, A-Tully Rinckey PLLC. I don't think we have any other questions here. Looks like Taylor says there's no additional questions. So again, thank you all for joining us. Have a great day.